The U.S. Supreme Court issued a unanimous 9-0 ruling that affects every law-abiding gun owner, homeowner, and parent who's ever asked if the government hits the wrong door, who pays the price. In Martin v. United States, the court vacated and remanded a lower court decision and made one thing crystal clear. The Federal Tort Claims Act (FTCA) still matters, and so do its guardrails. The much-debated law enforcement proviso doesn't erase the discretionary function exception, and that distinction will decide whether families caught in wrong-house raids can actually recover for assault, battery, false imprisonment, and negligence. This isn't abstract. It's about your home, your family, and your rights under the Fourth Amendment, and whether accountability follows the badge when mistakes turn violent. Stay with me, I'll cut through the legal maze. FTCA versus Bivens, planning versus execution, and what this ruling means for citizens, FFLs, and every American who values the Constitution and the sanctity of the front door. Let's start with the facts, because facts drive outcomes. Federal agents, relying in part on personal GPS intel, executed a pre-dawn operation at the wrong Atlanta home. A flashbang detonated. Residents were detained and handcuffed. The property was damaged. Only later did agents realize wrong door. The family filed suit under the Federal Tort Claims Act (FTCA), pleading negligence and intentional torts, assault, battery, and false imprisonment, seeking compensation for the physical, emotional, and property harms inflicted during the raid. Procedurally, the case bounced between the District Court and the 11th Circuit, with disputes centering on whether FTCA exceptions barred the claims. The Supreme Court stepped in and, in a unanimous 9-0 opinion, vacated and remanded. The court clarified that the FTCA's law enforcement proviso in Section 2680H reopens certain intentional tort claims against federal officers, but it does not erase the FTCA's separate discretionary function exception in Section 2680A. Translation: some claims may proceed, others may still be blocked, depending on whether the challenged conduct involved policy-laden discretion or violated specific mandatory directives. Why this matters for ordinary people when government force crosses your threshold by mistake. Accountability should not end at the badge. Martin confirms there is a pathway, but it is narrow, technical, and state law dependent. Under the Federal Tort Claims Act (FTCA), you may sue the United States for wrongful conduct much like you would sue a private person under state tort law. Congress, however, limited that waiver of immunity. Two guardrails matter most here. First, the intentional tort exception in Section 2680H usually blocks assault or battery claims against the government, but a law enforcement proviso reopens the door when the tortfeasor is a federal law enforcement officer acting in that role. That is the pathway the Martins used for assault, battery, and false imprisonment. Second, the discretionary function exception in Section 2680A preserves immunity when the challenged conduct turns on judgment or choice rooted in policy considerations, planning an operation, allocating manpower, choosing tactics, unless a specific immature mandatory directive removes discretion. In practice, the government nearly always invokes Section 2680A, claiming that pre-raid planning, target selection, and execution methods are policy-laden choices Congress meant to shield. Plaintiffs respond that agents violated mandatory rules or that the misconduct was operational negligence with no policy dimension. Martin instructs courts to sort these boundaries carefully, claim by claim and act by act, rather than treating the law enforcement proviso as a universal override. The upshot is pragmatic, certain intentional tort theories, like excessive force unmoored from policy, may proceed, while negligence tied to planning can still be barred. Whether you can recover will depend on your state law analogs and whether the conduct falls inside or outside the sphere of discretionary judgment. The court did not create a new constitutional right, nor did it abolish FTCA defenses. It performed the textual housekeeping Congress's structure demands. The law enforcement proviso modifies the intentional tort exception, not the discretionary function exception. The opinion vacates the 11th Circuit and sends the case back to apply the discretionary function test properly to each claim. Equally important is what the court didn't say. It didn't hold that every wrong door raid automatically triggers FTCA liability. It didn't convert tactical misjudgments into strict liability, and it didn't expand the FTCA beyond Congress's design. Instead, the court insisted on discipline courts must ask whether a specific statute, regulation, or operations order made the officer's conduct non-discretionary, and thus outside Section 2680AA, or whether the act involved judgment grounded in policy, and thus inside Section 2680A. For citizens, that means evidence, the existence of mandatory directives, the timeline of the raid, the intel sources used, any internal briefings, and post-incident reporting can decide whether claims live or die. When the FTCA route narrows, some plaintiffs look to Bivens, a judge-made remedy allowing suits for constitutional violations by federal officers in their individual capacities. The core of Bivens is Fourth Amendment violations by federal narcotics agents during arrests or searches. Over the last 4 decades, the Supreme Court has refused to extend Bivens to most new contexts and repeatedly labeled expansion disfavored. The 2025 landscape illustrates the point. In Goldie v. Fields 2025, the court reiterated that courts must use a 2-step restraint before recognizing new Bivens contexts. Yet, not all claims are doomed. The First Circuit in Arias Versa, Hertzen 2025, allowed a Fourth Amendment excessive force claim against DEA agents to proceed because it sits very close to the original Bivens blueprint federal narcotics officers, standard arrest setting, alleged excessive force. Other circuits remain more restrictive. For victims of wrong door raids, the relevance is direct if FTCA claims get blocked by Section 2680A. A Bivens claim may still survive if the facts are on model with classic Bivens scenarios, but if your case involves new contexts e.g. no-detention conditions, cross-border incidents, immigration enforcement with novel features, expect courts to decline Bivens and steer you back to statutory or administrative remedies. Bottom line, Bivens is narrow, but not dead. Crafting a viable claim requires tight factual pleading that mirrors the Bivens core rather than testing new ground. On remand, the 11th Circuit has to do the hard sorting planning versus execution, policy versus operations, discretion versus mandatory rules. The central questions practically write themselves. Did agents follow mandatory verification protocols, accurate address confirmation, cross-checks, geolocation standards, or did they operate within a zone of judgment that Section 2680A protects where flashbangs, no-knock entries, or pre-dawn timing required by written directives? Or were those operational choices, if they were choices? The government would press for discretionary immunity on scene. Did officers breach mandatory use of force policies? For example, rules governing pointing weapons at compliant bystanders, cuffing minors, or the duration of detention. The more specific and mandatory the directive, the stronger the path to escape Section 2680A and preserve intentional tort claims under the law enforcement proviso. Finally, because the FTCA mirrors state tort law, each count must have a private person analog under Georgia law: assault, battery, false imprisonment, negligence, or property damage. No analog, no FTCA liability. This framework doesn't guarantee victory, but it forces accountability to turn on rules, fact, and causation, not on blanket immunity. If the government hits the wrong door, respond with discipline, not anger. Once the scene is safe, preserve evidence. Note exact timestamps. Take photos and video. Inventory damaged property, and record medical effects and any lost work. Identify witnesses, neighbors, delivery drivers, bystanders, and secure their contact information. Through counsel, request records that expose what really happened, the incident report, search warrant affidavit, any after-action review, and available body-worn or in-car video. Paper trails often reveal whether mandatory directives were broken. Next, map your claims to state law. Because FTCA liability mirrors state torts, your attorney will align the facts with assault, battery, false imprisonment, trespass, conversion, or negligence. Whatever your state recognizes, expect the government to run the Section 2680 a playbook, insisting that planning and tactics were discretionary. Your job is to show either that a mandatory rule removed discretion or that the misconduct was operational rather than a policy judgment. Consider Bivens carefully. If your facts mirror the Bivens core, federal narcotics-type agents, a Fourth Amendment arrest search, and excessive force, a personal capacity claim may proceed subject to qualified immunity. If your facts depart from that template, temper expectations and explore other avenues for FFLs and ranges. Professionalism after the event can determine whether you recover or absorb the loss. Maintain robust surveillance coverage, entry logs, and a written post-incident SOP. Train staff to preserve the scene, secure evidence, and document injuries, and keep counsel on call. Above all, stay principled. The aim is accountability, not vengeance. A disciplined case that vindicates the Fourth Amendment serves your family, your community, and the constitutional limits that protect us all. Confusion about the ATF's stabilizing brace rule. Final Rule 2021 R08F is common in any discussion involving federal raids and firearms configurations. As of now, the rule has been set aside nationwide, and agencies have indicated a non-enforcement posture while litigation proceeds. What this does not mean is that short-barreled rifles are unregulated. It means the 2023 brace reclassification is not the active basis for enforcement today. The statutory definitions in the NFA and GCA still control, and other criminal laws still apply. Practical counsel do not register or reconfigure based solely on the vacated rule. Verify current status from official sources and consult counsel. Document your firearms configuration history photos, dates, parts, so that if the legal posture shifts, you can demonstrate good faith compliance under the FTCA. You sue the United States itself. Damages follow state tort law. Punitive damages are off the table, and cases are tried to the judge, not a jury. Success improves when you can show that a mandatory directive was violated or that the misconduct was operational rather than a policy judgment. Because Section 2680A and other exceptions loom over every claim. By contrast, Bivens targets individual federal officers for constitutional violations and is constrained by qualified immunity. Modern courts disfavor new contexts, so viability rises when your facts mirror the Bivens core. Federal narcotics-type officers, a Fourth Amendment arrest or search, and alleged excessive force or unlawful search, and it falls as your case strays beyond that template. The conservative constitutional principle is steady and simple: government power must be bounded. Martin does not promise payouts. It promises a fair fight over the right questions. Text, history, structure, and facts, so that when the wrong door is breached, the Constitution still stands between the citizen and the state. Here's the bottom line: when the government gets the wrong door, citizens shouldn't get the wrong end of justice. Martin Vs., United States, a 9-0 reminder from the Supreme Court. doesn't abolish defenses. It demands discipline. Read the statute, apply the limits, and respect the line between policy discretion and mandatory rules. For you and your family, that means document everything. Understand FTCA versus Bivens, and insist that the Fourth Amendment still has teeth at your threshold. We'll track the 11th Circuit on remand and report what it means in practice. Until then, stand calm, stand prepared, and stand on the Constitution.